This audio case is brought to you by Laudio. Dodge v. Ford Motor Co. Michigan Supreme Court, 1919. Opinion. Ostrander, J., after stating the facts. The authorized capital stock of the defendant company is $2 million. Its capital, in July 1916, invested in some form of property including accounts receivable, was $78,278,418.65, and less liabilities other than capital stock was more than $60 million. Besides this, it had and was using as capital nearly $54 million in cash or the equivalent of cash. It is contended by plaintiffs that because the statute has prescribed that the total authorized capital stock shall be not less than $1,000 and not more than $25 million, now $50 million, the capital of any corporation organized under the Act may not lawfully exceed $25 million, now $50 million. In the argument presented by them, the term capital is used as meaning, quote, the aggregate of the sums subscribed and paid in or secured to be paid in by the shareholders, with the addition of all gains or profits realized in the use and investment of those sums, or, if losses have been incurred, then it is the residue after deducting such losses, end quote. Pointing out that the shares of stock are at all times representative of the capital, whatever it may be, it is said that the learned trial judge decided that, quote, it was the legislative intent to prohibit a corporation having a capital in excess of the maximum limitation, whether that excess was acquired by contributions from stockholders or from profits on those contributions, end quote. And, in the judgment of counsel for plaintiffs, the essence of the reasoning employed by the trial judge may be and is stated by them in this language. Quote, looking at the statute, the history of the times, and the constitutional provision respecting corporations, it appears that the limitation in question was put in the statute because it was believed that mischief would result unless a restriction was placed upon corporate capital, that it was the intent of the statute to prevent this mischief, that to permit corporations to increase their capital at pleasure from undivided profits would frustrate that intent and give to old corporations powers, rights, and privileges which were not given to new corporations, and thus make corporations unequal before the law, contrary to the intent of the provision in our Constitution, respecting corporations to place them all on a basis of equality, end quote. It was the opinion of the three judges to whom was presented the application for a temporary restraining order that the statute, in the language referred to, does not limit the amount of capital, that portion of the assets of a corporation, regardless of their source, utilized for the conduct of the corporate business for the purpose of deriving gains and profits, which a corporation organized under the Act may lawfully possess. The term capital stock, in its primary sense, means the fund, property, or other means contributed or agreed to be contributed by shareholders as the financial basis for the prosecution of the business of the corporation, being made directly through stock subscriptions or indirectly through the declaration of stock dividends. The capital stock of a corporation is always representative of the net assets of the corporation, whatever they may be, and so a share of stock may be worth more or less than its par value, because it is representative of an aliquot part of the net assets of the corporation. The section of the statute with which we are dealing relates to the organization of corporations, and plainly, it is the legislative intent that no more than $50 million of capital shall be, in the first instance, aggregated and embarked in business under this law. It has been the policy of the state, unlike that of most of the states, to limit the aggregate of capital, which in the first instance may be employed in corporate enterprises. But the history of legislation is not evidence of a continuing state policy which limits the capital assets of corporations. Act No. 41, Laws 1853, authorized the formation of manufacturing corporations. It contained the provision, Section 67, quote, The amount of the capital stock in every such corporation shall be fixed and limited by the stockholders in their articles of association, and shall in no case be less than $10,000, nor more than $500,000, and shall be divided into shares of $25 each. The capital stock may be increased, and the number of shares at any meeting of the stockholders called for that purpose, provided that the amount so increased shall not, with the existing capital, exceed $500,000. End quote. In 1875, Act No. 89, this law was amended. As to corporations engaged in mining or manufacturing iron, steel, silver, lumber, or copper, the maximum limit of capital stock was fixed at $2,500,000. As to any other manufacturing corporation, the limit was $500,000, and it was expressly subject to these limitations that the capital stock was permitted to be increased. At the same session, Act No. 187 was passed for the incorporation of manufacturing companies. The minimum limit of capital stock was fixed at $10,000, which might be increased by stockholders, the maximum limit being $2,500,000. In 1881, Act No. 257, the maximum was increased to $5 million. Act No. 232 of the Public Acts of 1885 was a revision of laws for incorporating manufacturing companies. By its terms, the articles of incorporation were required to state the amount of capital stock, not less than $5,000 or more than $5 million, except that corporations for manufacturing cheese or other products of milk might have not less than $1,000 capital stock. The express terms are that, subject to these limitations, the capital stock may be increased or diminished, etc., etc. In argument, significance is attached to the language employed in the Act of 1853 authorizing an increase of capital stock, but providing that the amount of the increase with the existing capital shall not exceed the maximum of $500,000. Significance is also attached to the language in the amending acts which permit an increase of capital stock subject to the limitations as to the minimum and maximum of capital stock. Assuming that the legislature, in passing the law of 1853, had in view the distinction between capital stock and capital, or capital assets, and intended a maximum limitation of the amount of capital, the assumption must, of course, rest upon the language employed in the law. When the legislature in the later act omitted the words upon which the assumption is based, no reason is apparent for the conclusion that the limitation of capital was still intended. If the Act of 1853 contains evidence of a policy limiting capital assets, the Act of 1903 contains no such evidence. There is no apparent reason for entering upon the task of interpreting or construing language which is self-interpreting, which has a clear, reasonable meaning. The same general implications are to be drawn from the phrase "not more than" as from the phrase "not less than." We are not called upon to find a reason for the policy of limiting the capital stock or for the failure to also limit the value of the assets which may at any time be employed in the corporate business. We may assume a legislative reason, but may not assume that because a possible reason may be given for a further limitation, such further limitation must be implied. The reasons given for a different interpretation of the language, reasons which introduce matter not in the statute, are inconclusive. If the claimed statute limitation exists, it is imperative. It is manifestly impracticable, if not impossible, to limit the use in its business by a corporation of any size of its profits, to require that, when organized with the maximum amount of capital stock, all profits shall be set aside. It is conceded in argument that there must be some variation, some leeway, but, if any, how much? It may be supposed that the legislature looked with disfavor upon an initial aggregation of capital exceeding a certain amount. It cannot be supposed that it looked with disfavor upon a profitable corporate existence. Subscriptions to capital stock may be paid for in property valued by those associating. It may be that a patent is contributed, which, until exploited, has only an estimated potential value, no selling value. But after exploitation, would sell for more than the maximum limit fixed for capital stock. No one would contend that a $50 million manufacturing corporation could not borrow money for the purposes of its business. Of course, if it borrowed, it would owe for the money, and, as a matter of bookkeeping, would not by borrowing expand its capital assets. But, in fact, at the expense of a small rate of interest, it might add $50 million to the capital actually employed in the business. Experience would not lead to the belief that any manufacturing corporation of any size would continue to embark in the enterprise such profits as competition permitted and stockholders were willing to forego to the public detriment. It happens that the Ford Motor Company has had an unusual, a phenomenal experience, but this affords no reason for finding the meaning in the statute which plaintiffs insist shall be given to it. That no limit is in terms placed upon the value of assets, capital, which may be employed, is a circumstance supporting the conclusion that none was intended. Any aggregation of capital from $1,000 to $50 million is now permitted, invited, to be embarked in business under this statute. The corporations formed to compete among themselves and with foreign corporations admitted to do business in the state. The purpose of any organization under the law is earnings, profit. Undistributed profits belong to the corporation, and, so far as any limitation can be found in this act, may be lawfully employed as capital. If the meaning of the law were more doubtful, it would be prudent, if not imperative, that the legislature be left to make plain what is supposed to be obscure. There is little, if anything, in the bill of complaint which suggests the contention that the smelting of iron ore as a part of the process of manufacturing motors is or will be an activity ultra vires the defendant corporation. On the contrary, the bill charges that the erection of smelters and such other buildings, machinery, and appliances as are intended to go along with the business of smelting ore is part of a general plan of expansion of the business of defendant corporation, which is in itself unwise, and which is put into operation for the purpose of absorbing profits which ought to be distributed to shareholders. Restraint is asked not because the smelting business is ultra vires the corporation, but because the whole plan of expansion is inimical to shareholders' rights and was formulated and will be carried out in defiance of those rights. The gray iron parts of a Ford weigh in the rough 268.90 pounds, and when finished, 215.71 pounds. This iron, as now made by defendants, costs per car, at the prices of iron when the cause was tried, $11.184. The malleable iron parts weigh, finished, per car, 69.63 pounds, and would cost $6.757. The total cost per car of gray and malleable iron parts is less than $18. The smelter proposition involves, of course, much more than the initial expenditure for a plant. It involves the use of a large amount of capital to secure the finished product for the cars. Quantities of iron must be purchased and carried in stock. Coal for the coke ovens must be purchased. The plant must be maintained. If the plant produces the necessary iron and 800,000 cars are made in a year, something more than 270 million pounds of iron will be produced, and if, as is claimed by Mr. Ford, the cost is reduced to the company by one-half, and better iron made, a saving of $9 or $10 on the cost of each car will be the result. Presumably, this saving will also be reflected in the profits made from sales of parts. Ultimately, the result will be either a considerable additional profit upon each car sold, or it will permit a reduction in the selling price of cars and parts. The process proposed to be used has not been used commercially. The contention that the project is ultra vires the defendant corporation appears to have been made upon the application for a preliminary restraining order, and at the hearing on the merits as a reason for denying the right to invest instead of distributing the money which the proposed plant will cost, with no claim of surprise upon the part of defendants. Strictly, upon the pleadings, the question of ultra vires is not for decision, and this is not seriously denied. Assuming, however, in view of the course taken at the hearing, it is proper to express an opinion upon the point, it must be said that to make castings from iron ore rather than to make them from pig iron, as defendant is now doing, eliminating one usual process, is not beyond the power of the corporation. In its relation to the finished product, iron ore, an article of commerce, is not very different from lumber. It is admitted that the defendant company may not undertake to smelt ore except for its own uses. Defendant corporation is organized to manufacture motors and automobiles and their parts. To manufacture implies the use of means of manufacturing as well as the material. No good reason is perceived for saying that as matter of power it may not manufacture all of an automobile. In doing so, it need not rely upon the statute grant of incidental powers. Extreme cases may be put as, for example, if it may make castings from iron ore, may it invest in mines which produce the ore, and in means for transporting the ore from mine to factory. Or if it may make the rubber tires for cars, may it own and exploit a rubber plantation in Brazil or elsewhere. No such case is presented, and until presented, need not be considered. As we regard the testimony as failing to prove any violation of antitrust laws, or that the alleged policy of the company, if successfully carried out, will involve a monopoly, other than such as accrues to a concern which makes what the public demands and sells it at a price which the public regards as cheap or reasonable, the case for plaintiffs must rest upon the claim, and the proof in support of it, that the proposed expansion of the business of the corporation, involving the further use of profits as capital, ought to be enjoined because inimical to the best interests of the company and its shareholders, and upon the further claim that in any event the withholding of the special dividend asked for by plaintiffs is arbitrary action of the directors requiring judicial interference. The rule which will govern courts in deciding these questions is not in dispute. It is, of course, differently phrased by judges and by authors, and as the phrasing in a particular instance may seem to lean for or against the exercise of the right of judicial interference with the actions of corporate directors, the context, or the facts before the court, must be considered. This court, in Hunter v. Roberts, Throp & Co., 83 Mich. 6371, recognized the rule in the following language, quote, "It is a well-recognized principle of law that the directors of a corporation and they alone have the power to declare a dividend of the earnings of the corporation and to determine its amount. Courts of equity will not interfere in the management of the directors unless it is clearly made to appear that they are guilty of fraud or misappropriation of the corporate funds, or refuse to declare a dividend when the corporation has a surplus of net profits, which it can, without detriment to its business, divide among its stockholders, and when a refusal to do so would amount to such an abuse of discretion as would constitute a fraud or breach of that good faith which they are bound to exercise towards the stockholders." End quote. In To Cook on Corporations, 7th edition, section 545, it is expressed as follows: "The board of directors declare the dividends, and it is for the directors and not the stockholders to determine whether or not a dividend shall be declared. When, therefore, the directors have exercised this discretion and refused to declare a dividend, there will be no interference by the courts with their decision, unless they are guilty of a willful abuse of their discretionary powers, or of bad faith, or of a neglect of duty. It requires a very strong case to induce a court of equity to order the directors to declare a dividend, inasmuch as equity has no jurisdiction unless fraud or a breach of trust is involved. There have been many attempts to sustain such a suit, yet, although the court do not disclaim jurisdiction, they have quite uniformly refused to interfere. The discretion of the directors will not be interfered with by the courts unless there has been bad faith, willful neglect, or abuse of discretion." Quote, "Accordingly, the directors may, in the fair exercise of their discretion, invest profits to extend and develop the business, and a reasonable use of the profits to provide additional facilities for the business cannot be objected to or enjoined by the stockholders." End quote. In 1 Morowitz on Corporations, 2nd edition, section 447, It is stated, quote, "Profits earned by a corporation may be divided among its shareholders, but it is not a violation of the charter if they are allowed to accumulate and remain invested in the company's business. The managing agents of a corporation are impliedly invested with a discretionary power with regard to the time and manner of distributing its profits. They may apply profits in payment of floating or funded debts, or in development of the company's business, and so long as they do not abuse their discretionary powers or violate the company's charter, the courts cannot interfere. But it is clear that the agents of the corporation, and even the majority, cannot arbitrarily withhold profits earned by the company, or apply them to any use which is not authorized by the company's charter. The nominal capital of a company does not necessarily limit the scope of its operations. A corporation may borrow money for the purpose of enlarging its business, and in many instances it may use profits for the same purpose. But the amount of the capital contributed by the shareholders is an important element in determining the limit beyond which the company's business cannot be extended by the investment of profits. If a corporation is formed with a capital of $100,000 in order to carry on a certain business, no one would hesitate to say that it would be a departure from the intention of the founders to withhold profits in order to develop the company's business until the sum of $500,000 had been amassed, unless the company was formed mainly for the purpose of accumulating the profits from year to year. The question, in each case, depends upon the use to which the capital is put and the meaning of the company's charter. If a majority of the shareholders or the directors of a corporation wrongfully refuse to declare a dividend and distribute profits earned by the company, any shareholder feeling aggrieved may obtain relief in a court of equity. It may often be reasonable to withhold part of the earnings of a corporation in order to increase its surplus fund, when it would not be reasonable to withhold all the earnings for that purpose. The shareholders forming an ordinary business corporation expect to obtain the profits of their investment in the form of regular dividends. To withhold the entire profits merely to enlarge the capacity of the company's business would defeat their just expectations. After the business of a corporation has been brought to a prosperous condition and necessary provision has been made for future prosperity, a reasonable share of the profits should be applied in the payment of regular dividends, though a part may be reserved to increase the surplus and enlarge the business itself." End quote. One other statement may be given from Park v. Grant Locomotive Works, 40 NJ Ec. 114. Quote, "In cases where the power of the directors of a corporation is without limitation and free from restraint, they are at liberty to exercise a very liberal discretion as to what disposition shall be made of the gains of the business of the corporation. Their power over them is absolute as long as they act in the exercise of their honest judgment. They may reserve of them whatever their honest judgment approves as necessary or judicious for repairs or improvements, and to meet contingencies, both present and prospective. And their determination in respect of these matters, if made in good faith and for honest ends, though the result may show that it was injudicious, is final, and not subject to judicial revision." End quote. It is not necessary to multiply statements of the rule. To develop the points now discussed, and to a considerable extent they may be developed together as a single point, it is necessary to refer with some particularity to the facts. When plaintiffs made their complaint and demand for further dividends, the Ford Motor Company had concluded its most prosperous year of business. The demand for its cars at the price of the preceding year continued. It could make and could market in the year beginning August 1, 1916, more than 500,000 cars. Sales of parts and repairs would necessarily increase. The cost of materials was likely to advance, and perhaps the price of labor, but it reasonably might have expected a profit for the year of upwards of $60 million. It had assets of more than $132 million, a surplus of almost $112 million, and its cash on hand and municipal bonds were nearly $54 million. Its total liabilities, including capital stock, was a little over $20 million. It had declared no special dividend during the business year except the October 1915 dividend. It had been the practice under similar circumstances to declare larger dividends. Considering only these facts, a refusal to declare and pay further dividends appears to be not an exercise of discretion on the part of the directors, but an arbitrary refusal to do what the circumstances required to be done. These facts and others call upon the directors to justify their action, or failure or refusal to act. In justification, the defendants have offered testimony tending to prove, and which does prove, the following facts. It had been the policy of the corporation for a considerable time to annually reduce the selling price of cars while keeping up or improving their quality. As early as in June 1915, a general plan for the expansion of the productive capacity of the concern by a practical duplication of its plant had been talked over by the executive officers and directors and agreed upon, not all of the details having been settled and no formal action of directors having been taken. The erection of a smelter was considered, and engineering and other data in connection therewith secured. In consequence, it was determined not to reduce the selling price of cars for the year beginning August 1, 1915, but to maintain the price and to accumulate a large surplus to pay for the proposed expansion of plant and equipment, and perhaps to build a plant for smelting ore. It is hoped by Mr. Ford that eventually 1 million cars will be annually produced. The contemplated changes will permit the increased output. The plan, as affecting the profits of the business for the year beginning August 1, 1916 and thereafter, calls for a reduction in the selling price of the cars. It is true that this price might be at any time increased, but the plan called for the reduction in price of $80 a car. The capacity of the plant, without the additions thereto voted to be made, without a part of them at least, would produce more than 600,000 cars annually. This number, and more, could have been sold for $440 instead of $360, a difference in the return for capital, labor, and materials employed of at least $48 million. In short, the plan does not call for and is not intended to produce immediately a more profitable business, but a less profitable one. Not only less profitable than formerly, but less profitable than it is admitted it might be made. The apparent immediate effect will be to diminish the value of shares and the returns to shareholders. It is the contention of plaintiffs that the apparent effect of the plan is intended to be the continued and continuing effect of it, and that it is deliberately proposed, not of record and not by official corporate declaration, but nevertheless proposed, to continue the corporation henceforth as a semi-eleemosynary institution and not as a business institution. In support of this contention, they point to the attitude and to the expressions of Mr. Henry Ford. Mr. Henry Ford is the dominant force in the business of the Ford Motor Company. No plan of operations could be adopted unless he consented, and no board of directors can be elected whom he does not favor. One of the directors of the company has no stock. One share was assigned to him to qualify him for the position, but it is not claimed that he owns it. A business, one of the largest in the world and one of the most profitable, has been built up. It employs many men at good pay. My ambition, said Mr. Ford, is to employ still more men to spread the benefits of this industrial system to the greatest possible number, to help them build up their lives and their homes. To do this, we are putting the greatest share of our profits back in the business. Quote, with regard to dividends, the company paid 60% on its capitalization of $2 million, or $1,200,000, leaving $58 million to reinvest for the growth of the company. This is Mr. Ford's policy at present, and it is understood that the other stockholders cheerfully accede to this plan. End quote. He had made up his mind in the summer of 1916 that no dividends other than the regular dividends should be paid, quote, for the present. End quote. Quote, for how long? Had you fixed in your mind any time in the future when you were going to pay? No. That was indefinite in the future? That was indefinite, yes, sir. End quote. The record, and especially the testimony of Mr. Ford, convinces that he has, to some extent, the attitude towards shareholders of one who has dispensed and distributed to them large gains, and that they should be content to take what he chooses to give. His testimony creates the impression, also, that he thinks the Ford Motor Company has made too much money, has had too large profits, and that although large profits might still be earned, a sharing of them with the public by reducing the price of the output of the company ought to be undertaken. We have no doubt that certain sentiments, philanthropic and altruistic, creditable to Mr. Ford, had large influence in determining the policy to be pursued by the Ford Motor Company, the policy which has been herein referred to. It is said by his counsel that, quote, although a manufacturing corporation cannot engage in humanitarian works as its principal business, the fact that it is organized for profit does not prevent the existence of implied powers to carry on with humanitarian motives such charitable works as are incidental to the main business of the corporation, end quote. And again, quote, as the expenditures complained of are being made in an expansion of the business which the company is organized to carry on, and for purposes within the powers of the corporation, as hereinbefore shown, the question is as to whether such expenditures are rendered illegal because influenced to some extent by humanitarian motives and purposes on the part of the members of the board of directors, end quote. In discussing this proposition, counsel have referred to decisions such as Hawes v. Oakland, Taunton v. Royal Insurance Co., Henderson v. Bank of Australasia, Steinway v. Steinway & Sons, People ex rel. Metropolitan Life Insurance Company v. Hotchkiss. These cases, after all, like all others in which the subject is treated, turn finally upon the point, the question, whether it appears that the directors were not acting for the best interests of the corporation. We do not draw in question, nor do counsel for the plaintiffs do so, the validity of the general propositions stated by counsel, nor the soundness of the opinions delivered in the cases cited. The case presented here is not like any of them. The difference between an incidental humanitarian expenditure of corporate funds for the benefit of the employees, like the building of a hospital for their use and the enjoyment of agencies for the betterment of their condition, and a general purpose and plan to benefit mankind at the expense of others, is obvious. There should be no confusion, of which there is evidence, of the duties which Mr. Ford conceives that he and the stockholders owe to the general public, and the duties which, in law, he and his co-directors owe to protesting minority stockholders. A business corporation is organized and carried on primarily for the profit of the stockholders. The powers of the directors are to be employed for that end. The discretion of directors is to be exercised in the choice of means to attain that end and does not extend to a change in the end itself, to the reduction of profits, or to the non-distribution of profits among stockholders in order to devote them to other purposes. There is committed to the discretion of directors a discretion to be exercised in good faith, the infinite details of business, including the wages which shall be paid to employees, the number of hours they shall work, the conditions under which labor shall be carried on, and the prices for which products shall be offered to the public. It is said by appellants that the motives of the board directors are not material and will not be inquired into by the court so long as their acts are within their lawful powers. As we have pointed out, and the proposition does not require argument to sustain it, it is not within the lawful powers of a board of directors to shape and conduct the affairs of a corporation for the merely incidental benefit of shareholders and for the primary purpose of benefiting others. And no one will contend that if the avowed purpose of the defendant directors was to sacrifice the interests of shareholders, it would not be the duty of the courts to interfere. We are not, however, persuaded that we should interfere with the proposed expansion of the business of the Ford Motor Company. In view of the fact that the selling price of products may be increased at any time, the ultimate results of the larger business cannot be certainly estimated. The judges are not business experts. It is recognized that plans must often be made for a long future, for expected competition, for a continuing as well as an immediately profitable venture. The experience of the Ford Motor Company is evidence of capable management of its affairs. It may be noticed, incidentally, that it took from the public the money required for the execution of its plan, and that the very considerable salaries paid to Mr. Ford and to certain executive officers and employees were not diminished. We are not satisfied that the alleged motives of the directors, insofar as they are reflected in the conduct of the business, menace the interests of shareholders. It is enough to say, perhaps, that the Court of Equity is at all times open to complaining shareholders having a just grievance. Assuming the general plan and policy of expansion and the details of it to have been sufficiently formally approved at the October and November 1917 meetings of directors, and assuming further that the plan and policy and the details agreed upon were for the best ultimate interest of the company and therefore of its shareholders, what does it amount to in justification of a refusal to declare and pay a special dividend or dividends? The Ford Motor Company was able to estimate with nicety its income and profit. It could sell more cars than it could make. Having ascertained what it would cost to produce a car and to sell it, the profit upon each car depended upon the selling price. That being fixed, the yearly income and profit was determinable, and with slight variations was certain. There was voted, for the smelter, $11,325,000. As to the remainder voted, there is no available way for determining how much had been paid before the action of directors was taken and how much was paid thereafter. But assuming that the plans required an expenditure sooner or later of $9,895,000 for duplication of the plant, and for land and other expenditures $3 million, the total is $24,220,000. The company was continuing business at a profit, a cash business. If the total cost of proposed expenditures had been immediately withdrawn in cash from the cash surplus, money and bonds, on hand August 1, 1916, there would have remained nearly $30 million. Defendants say, and it is true, that a considerable cash balance must be at all times carried by such a concern. But, as has been stated, there was a large daily, weekly, monthly receipt of cash. The output was practically continuous and was continuously and within a few days turned into cash. Moreover, the contemplated expenditures were not to be immediately made. The large sum appropriated for the smelter plant was payable over a considerable period of time, so that, without going further, it would appear that, accepting and approving the plan of the directors, it was their duty to distribute on or near the 1st of August, 1916, a very large sum of money to stockholders. In reaching this conclusion, we do not ignore but recognize the validity of the proposition that plaintiffs have, from the beginning, profited by, if they have not lately, officially, participated in, the general policy of expansion pursued by this corporation. We do not lose sight of the fact that it had been, upon an occasion, agreeable to the plaintiffs to increase the capital stock to $100 million by a stock dividend of $98 million. These things go only to answer other contentions now made by plaintiffs, and do not and cannot operate to stop them to demand proper dividends upon the stock they own. It is obvious that an annual dividend of 60% upon $2 million, or $100,000 to $200,000, is the equivalent of a very small dividend upon $100 million or more. The decree of the court below fixing and determining the specific amount to be distributed to stockholders is affirmed. In other respects, except as to the allowance of costs, the said decree is reversed. Plaintiffs will recover interest at 5% per annum upon their proportional share of said dividend from the date of the decree of the lower court. Appellants will tax the costs of their appeal, and 2/3 of the amount thereof will be paid by plaintiffs. No other costs are allowed. Steer, Fellows, Brooke, and Stone, J.J. Concurred with Ostrander J. Concurrence. Moore, J. Concurring. I agree with what is said by Justice Ostrander upon the subject of capitalization. I agree with what he says as to the smelting enterprise on the River Rouge. I do not agree with all that is said by him in his discussion of the question of dividends. I do agree with him in his conclusion that the accumulation of so large a surplus establishes the fact that there has been an arbitrary refusal to distribute funds that ought to have been distributed to the stockholders as dividends. I therefore agree with the conclusion reached by him upon that phase of the case. Bird, CJ and Kuhn J concurred, with Moore J. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.